As I indicated, my name is Floyd Jennings. My CV is in the resources. You can Google me and find out more than I might wish for you to know. I am a retired clergy member of the Texas Annual Conference. I've been a clinical psychologist for 40 years. I have been an attorney for somewhat less than 20. It's appropriate that I start this with a disclaimer. This presentation is not intended to be, nor should it be construed as supplanting consultation with your chancellor and or with GCFA Legal Services or consultation with your bishop, and the opinions expressed here are my own. Now, the issues that we're going to talk about are twofold. I'm going to talk about issues for the church, and I'm going to talk about issues for examiners. The issues for the church have to do with liability for the church with a plaintiff candidate and liability for the church with a third-party plaintiff. Specifically, does liability attach to annual conferences or any adjudicatory for conducting psychological evaluations of candidates? And does HIPAA or Title VII or the ADA apply to psycho evaluations of clergy? These are issues, the latter issues are issues of both for the church and for the MAS. For the ministerial assessment specialist, the question is, to what extent do MASs have liability for conducting evaluations of clergy candidates? What competing roles, if any, exist? What assessment issues have ethical and legal implications? And what special competencies are required for ethnically or racially diverse populations? First principle arises not from statutes, but from the Constitution, and I never leave home without a copy of it. In the First Amendment, it reads, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And it is the Establishment Clause and the Free Exercise Clause that relates to liability for the church in a host of ways, but particularly with plaintiff candidates. There's a beautiful quote from an 1871 case, Watson versus Jones, which states, "The law knows no heresy and is committed to the support of no dogma, the establishment of no sect." By the way, the background of that case was it was a Louisville, Kentucky case where at the time of the Civil War, a Presbyterian congregation split down the middle, and the question was who had the property. And they obviously didn't have a good trust clause that would have helped decide that issue because both claimed the right to the property. And the court said it would be a vain consent and would lead to the total subversion of such religious bodies if anyone, aggrieved by one of their decisions, could appeal to the secular courts and have them reversed. So that leads us very quickly to a solution. There is no liability to the church from a candidate plaintiff for requiring psychological evaluations, for assessment of clergy candidates, or for that matter, almost any other conceivable requirement. The church could ask candidates to stand on their head in the light of a full moon and recite the Articles of Religion backward. And a candidate could say, I could probably recite the Articles backwards, but I'm really not good at standing on my head. And the church could say, oh well. We only take people who can stand on their heads and recite the Articles of Religion backwards. Now, I must admit that many candidates don't know what's in the Articles of Religion, particularly Article 5, The Scriptures contain all things necessary for salvation, and what is not to be found therein or proved thereby is not to be considered an article of faith. That's not the issue. The issue is the church has a right to require almost anything, however bizarre, of its candidates. Moreover, there are recently enacted statutes which say that neither the ADA nor Title VII apply. For example, somebody is here from Desert Southwest? Anybody? Hold up your hand and say, oh, okay. Well, you may remember this case. It was a 2004 case, Verse versus Desert Southwest Conference, the United Methodist Church. A pastor alleged that despite his history of an attention deficit disorder, dyslexia, and certain heart problems, he was able to perform his ministerial duties with minor accommodations. The church refused to make any accommodations and, according to his petition, forced him to resign from his pastoral position. That was his claim. He claimed discrimination on the basis of failure of the church to accommodate for his disabilities, and the court said, get out of here. We're simply not going to do that, deal with that issue. The basis for those decisions is the ministerial exception that arises out of the First Amendment establishment and free exercise clauses. And that exception has the effect of exempting the church from the application of Title VII and the ADA. Now, there's a caveat. This exception applies to clergy and the spiritual functions of the church, and not to lay employees per se. If you have a janitor, they're likely to be covered by Title VII and by the ADA. But I'm going to give you some examples where that would not apply to clergy. By the way, the courts, for example, have upheld the right of the Roman Catholic Church to hire only males in ordained positions. In a case that was an ADA case that occurred literally about 7 miles down the road. Anybody here from Central Texas? A few of you. Well, Richard, you are. In Combs versus Central Texas Conference, there was a young woman who had come out of the Baptist tradition and was an associate at First Church Hurst. She became pregnant and married, and she sought a family leave. And the church said, we can't afford to pay you for umpteen months. And she said, well, you're required to. I'm entitled, the Family Leave Act should apply to me as a clergy person. And the Fifth Circuit held as follows. In short, we cannot conceive how the federal judiciary could determine whether an employment decision concerning a minister was based on legitimate or illegitimate grounds without inserting ourselves into a realm where the Constitution forbids us to tread, the internal management of a church. Thus, we are persuaded that the First Amendment continues to give the church the right to select its ministers free from Title VII restrictions. As a matter of fact, there's a beautiful quote from a Baltimore Conference issue, Menker versus Baltimore Conference. The federal judge wrote as follows. This is actually a D.C. Circuit opinion. We cannot imagine an area of inquiry less suited to a temporal court for decision. Evaluation of the gifts and graces of a minister must be left to ecclesiastical institutions. I've already iterated the issues in Combs versus Central Texas. There are a multiplicity of other cases. There was a lovely decision in Rayburn versus the General of the Seventh-day Adventists. There was a young woman who was evidently quite bright. She had an MDiv and a Ph.D. in psychology, and she sought an associate position and was rejected, unsuccessfully sued, and the court's language was as follows. This case raises significant questions about the application of the civil rights laws to churches. Because the state scrutiny of the church's choice would infringe substantially on the church's free exercise of religion and would constitute impermissible government entanglement with church authority, we affirm the decision of the district court. They poured her out. It isn't going to happen. In every case in which this has occurred in the last 100 years, the result has been as I described. The Louisiana Conference, I don't know if there's anybody from Louisiana here, we had a case in the early 90s. It was an organist that sued under the ADA. Now, not an ordained person, but this was a person who had a host of physical problems and said that she could no longer perform her duties and was discharged. And in this case, the court extended the ministerial exception rule to the organist, and the reasoning was as follows. The ministerial exception encompasses all employees of a religious institution, whether ordained or not, whose primary functions serve its spiritual and pastoral mission. Similarly, there was a Catholic University case. It was a young woman who was religious. She was a member of an order who obtained a Ph.D. and taught in canon law and didn't get tenure and sued the university on those grounds, and the court essentially held similarly. We're not going to get involved in that. The actual original case, it was the oldest, one of the older ones, was a Salvation Army case. We had a member of the Salvation Army speak yesterday. And the Fifth Circuit first articulated the ministerial exception claims in regard to McClure, and the same language about an impermissible encroachment by the state into issues of religious freedom. Consequence is, although some have called GBHM and required, can we ask candidates to do this? The answer is absolutely. Not a problem. Now, is there liability for non-clergy employees? Yes, that's a different issue. Is there liability for third parties? You bet. Folks here in Central Texas know that very well. There was Barry Bailey, who was the pastor of First Church Fort Worth. By the way, from Texas, one understands that that city is not Fort Worth. That city is Fort Worth. He was pastor of First Church Fort Worth and engaged in a variety of sexual improprieties, and there were a multiplicity of suits in that case against him, against the annual conference, and all of those suits were successfully handled by settlement, but there was, even though the church had followed all the procedures to the letter of the law. It was not true in Missouri. We had a case in Missouri where there was some impropriety by a clergy member of the annual conference, and it was not well handled, and it resulted in extreme costs to the Missouri. I think that was at a time when we had two annual conferences in Missouri. On the other hand, well, let's talk about MASs. Now, for those of you who are MASs, the rules are different. Your liability is far greater. It could be any one of, in at least three areas. There could be regulatory violations, board complaints, malpractice claims, or even criminal prosecution for sexual misconduct. By the way, a number of adjudicatories now make it a criminal act for a mental health practitioner in the course of their professional practice to be involved in any sexual way with the beneficiary of their services. Whether this is a patient or a subject, an examinee is not relevant for the purposes of that law. And in Texas, they would extend that rule to clergy if they were involved in a counseling relationship, but we'll talk a little bit more about that. Now, the MAS liability is predicated upon what is called tort liability. It means that you have to have a duty, there is a breach of that duty by the examiner, and the damages that result are proximate to the breach. So what are some of the duties that you have as a ministerial assessment specialist? Well, first, competence. So that means you must always practice within the bounds of your competence. Duty to maintain confidentiality, duty to obtain consent for the release of information, disclosure of confidential information to entities of the church sans appropriate consent would expose you to liability. Duty of honesty and fair dealing, duty to maintenance of personal boundaries, duty of record keeping, all of that's the case. Now, there's specific issues in assessment. Ownership of records is among them. Now, while the general rule that we conceptualize it from the General Board's point of view is that as an MAS, you own all the data that you generate. You can certainly keep a copy of the report. The report, however, is owned by the annual conference. And there should be a release of information that the subject of the examinee has signed, waiving all rights of access to that information. Now, if you choose to get them, that's because out of your largesse, you agree to do that, but they have waived the right to the annual conference to use that information in any way the annual conference deems desirable, unless or until that consent has been withdrawn, and to the extent to which it has not been relied upon in the interim. Now, access to the reports varies from annual conference to annual conference. We just spoke to board representatives pointing out that the way we wrote the agreement to the process of the release of information is that in many annual conferences, the examinee has access to the information prior to its being sent to the annual conference and even has a right to make corrections therein in some instances. Another view would say they do not have right of access to the information until it has been submitted to the annual conference, but then they would have a disciplinary right, as well as general process right to access that information in their personal file. Records retention, however, is a different matter. You keep all your records, and you keep them pursuant to the regulation in the adjudicatory, in which are the jurisdiction in which you perform services. The church, however, has a records retention policy that is somewhat confused. The discipline says that it should be maintained according to policies generated by GCFA Legal Services, and their reasoning is circular. They essentially say that the annual conference should develop those policies and in accordance with the requirements of the discipline. In effect, we have two record-keeping systems. We don't need to get into this. This is technical. We have two record-keeping systems. We have supervisory records, and we have general personnel records, and they have different degrees of access to each. Let's talk quickly about some ethical issues. I'm at 18 minutes and counting, and I've only got 30, and I want to stop unless you ask some questions of me. Blind interpretation of data without disclosure of limitations is very troubling, and many states would prohibit that entirely. Now, note that I said without disclosure of the limitations. So if you do blind interpretations of data, you get the data, you interpret it, it's administered elsewhere, and you don't see the person, but you write a report based upon that. In many jurisdictions, that's prohibited, but in all jurisdictions, it would be incumbent upon the writer to indicate that those were the circumstances, and that the conclusions may be, therefore, tempered somewhat to a greater or lesser extent because of the lack of availability of access to the person in a face-to-face relationship. I find that very, very troubling, but others don't, and argue quite successfully that it's possible to do and have done so for a long period of time. Competence. Persons provide only such services and render such interpretations of test data as they may be qualified by education, training, and experience. Conflicts of interest. We've already spoken to this earlier. This deals with conflicting roles, and I want to speak about that in just a moment. But the roles of the examiner differ as to the stage at which you're examining the candidate, for candidacy, for aspirants. The issue is one of fitness. At commissioning, it's one of readiness. For final orders, it's one of effectiveness. There may be some conflict between examining and nurturing functions. Our interest in protecting the church is far greater at stage 1 than it is stage 2 or 3, in the sense that the church has already decided that they want the person, and they've invested a great deal, the church has, in their growth and nurturance. And the nurturing functions of the evaluation might be quite different for stage 1 or stage 2. There are some issues around conflicting roles in terms of loyalty. To whom do you owe a primary duty? To the church, to the candidate? Who is the client? And with that in mind, the Journal Board does have, although I just said it is not available on our regular website, but Meg can provide other ways where we can access it, a sample contract. I think it's desirable for any annual conference to have a contract with an examiner that specifies the terms, the rules, who owns the information, what the report shall include, who gets it, so that there is something quite clear in the relationship between the examiner and the annual conference, regardless of who the payor is, and that can be specified in the contract as well. As reporting adverse information, what duties exist from the examiner to the candidate are important. That probably needs to be spelled out in advance so the candidate is fully aware that if you uncover information which is of such a character that it's going to need to be reported, even if the candidate says no, the candidate's only option is to withdraw from the process because you're going to report it. And they would have to agree to that from the outset. I often tell candidates, anything you say can and may be reported to the bishop, and you understand these rights as I've read them to you. You're not entitled to an attorney. If you need an attorney, you're in serious trouble because First Amendment rights do not apply to these evaluations. And if you agree to that, then we can proceed. If not, it has been nice knowing you. There is a necessity for truly informed consent, as this is a third-party evaluation. Remember, I often tell candidates, the other day I had some blood drawn from me, and I began to understand the meaning of practicing medicine because the phlebotomist had difficulty with one arm and said, could I try the other? And I'm realizing I'm probably going to have to beg and plead to get a copy of these results because they're not going to go to me. They're going to go to my endocrinologist and my cardiologist, both of whom make a fortune off of me. Well, I will say to a candidate, this probably won't be that onerous, but the information that's generated out here is not yours and not for your benefit primarily. It will go to the church. Now, that's true particularly at the fitness stage. It becomes less so and a different kind of consent at a different stage. Treater or examiner. Note that in some jurisdictions, the examiner can be a treater or an examiner, but not both in the same case. Examinees in a forensic context where third parties are involved in the client do not necessarily have the same rights as patients, and I was instrumental in writing regulations in Texas which spell that out. Not many states do that, but they nonetheless operate on the same presumption. But who is the client is important. Finally, bottom line is that there's no liability to the church with a candidate plaintiff. There is third-party liability for misconduct of a host of kinds, and it is important that the church do due diligence. And many of the harrowing tales that I've heard have to do with the church's inattention to simple risk management in its selection of clergy at the initial stage. Exposure does reside to the church for lay employees of the church that are not involved in what the courts have called spiritual functioning, and liability exists for examiners on multiple levels. We're at 24 minutes and 41 seconds. I'd like to entertain questions from you as you may have. And by the way, you can, as I indicated, my CV is available. You can Google me. You can contact me at any time. I do all kinds of things for the church. I write briefs for the Judicial Council at the request of the Council of Bishops. I've done so for the General Board. As one of my wags on the committee has said, Jennings, have you ever had an opinion you were not willing to share? So, questions? Back here, yes, ma'am.
Yeah, this one applies mostly to the United Methodists, but we have a new category of people serving in solo ministry in our churches called CLMs. And part of my question is, are we taking on unnecessary liability if we don't do the same assessment of CLMs, psychological assessment of CLMs, as we do for local pastors and clergy?
CLMs by certified lay ministers?
Yes, and we're sending them out to do solo ministry as church
They are
pastors.
engaged in ministerial activities of the church. They are involved in the spiritual functions of the church. While I would not be so bold as to predict how any federal court would react, it would seem to me that, consistent with prior court decisions, that the ministerial exception and the First Amendment exception would apply to them. But there would also be substantial exposure to the church for third-party plaintiffs if any misconduct were to arise involving those persons. Back here, yes, sir.
Using your language, treater versus examiner, I know our board has run into several situations where in the process of interviewing, they would vote for a not yet for someone, refer them for help, therapy, but then want a report. So do you have any guidelines for that at that point? Because that feels like that's
As I recall, we have constructed, Greg, are you here someplace? Didn't we construct some guidelines on the issue of psychotherapy for persons in candidacy or in postulancy, however we describe it? Put simply, however, is that if we refer a person under such circumstances, there would need to be a contractual relationship with the provider, so that they would be willing to undertake an intervention on such grounds. And it would be far the better for that to be arranged in advance, rather than for the person to have been involved in treatment and then you discover that there is a war that is developing because the provider is reluctant to share information. So can you request that? Absolutely. But there would need to be a truly informed consent. Jerry, you want to speak to that?
Yes, thank you, Floyd, and thank you for the information. I think from a professional therapeutic standpoint, that is the kiss of death, to ask for a report from the therapist, because the client, the candidate, is in no way, if they have any intelligence whatsoever, going to share the depth of their struggle with you as a therapist, because it'll get reported to the conference. And so what we do is say, we will report that the candidate showed up and what dates, but we will not go beyond that. And I would seriously say that if you ask for a report from a therapist, it also puts the therapist in kind of a difficult spot, but the candidate will not use therapy effectively.
Dr. DeSobe is the executive director of a multiplicity of Samaritan centers in the Houston area, Garrett graduate and well recognized. And I would agree that that would make the psychotherapeutic enterprise somewhat troubling. Is it legally possible? It is. Another alternative then would be to arrange a subsequent examination by a different person other than the treater to maintain the role between treater and examiner. Greg.
We have a letter, some sort of a sample letter that therapists might consider reviewing that lays out a number of issues along these lines. It certainly is less than ideal for therapists and clients to work together where there's going to be some report required. At the same time, for some of them, it's the only way they get to keep their jobs, so they're motivated to do it. But there are a number of things that are good to consider and get straight ahead of time, like what level of disclosure is going to be requested so that the candidate can agree to it before getting started in the process. It's good to let the denominational officials know that the client would have the right to revoke permission at any time, so that if there's silence, it may be because the therapist can no longer speak. So the letter just lays out a number of the considerations that you might want to look at.
The issue around consent, Dr. Hinkle, you're also in a Samaritan Center, are you not?
At the moment.
And the executive director in Elkhart, Indiana. The issue around consent is important because consent is specific and time specific, and it can be withdrawn, except, of course, to the extent to which it has not already been relied upon in the interim. Sir.
A best practice that I found, Christopher Carlton, Director of Emory Clergy Care, I constitute the treatment wing of that organization. And often I am referred people that have issues to work on, and I work with them. One of the things I do is I do solicit informed consent up front, allowing them to know what will be reported. I try to be very general in what I report back, but one of the things that I found to be helpful is to actually have the client in the room when I compose the letter, so they know the content of what is going to be reported, and they have a chance to interact with me around how they feel about that. And that has been a helpful practice for me.
Thank you. We are at 31 minutes and 45 seconds. I had a 30-minute time limit, and I want to honor those boundaries, but Greg is pushing the limit.
As usual. Just adding to the previous idea, I tend to give the letter to the candidate and then say, do with this what you will.
Thank you all. It's been a privilege.